Charlene, welcome to All About Property.
Thank you, Cornelius.
The offer to purchase is probably the most important document that a buyer and seller would ever sign. What is an offer to purchase and why is it considered a binding agreement?
Okay, first of all, an offer to purchase is not in actual fact a binding agreement. Only the moment it's accepted by the seller within the time frame specified, it will be seen as a binding agreement.
What are the standard things that should be in an offer to purchase?
An offer to purchase will always start off with a description of the parties, the seller, the purchaser, then very importantly the purchase price and how it will be payable.
What are some of the some mistakes that can take place in an offer to purchase that might delay the registration process?
Little things like the correct spelling of the parties' names, ID numbers, marital status, actually follows through all the way and results in the bond instruction in the end also being incorrect, having to be amended at the bank, and have the consequence of another 10-day delay, for example.
A clause that's very prominent in an offer to purchase is the footstewards clause. Not a lot of people really understand this clause. Can you shed some light?
The footstewards clause means that you are buying the property as it is, which means in essence that you are buying it defects and all. It of course is always more than that, and there are aspects like the Consumer Protection Act that's confused issues a bit. But if it is a normal sale, not by a developer, not through direct marketing, the Consumer Protection Act will not apply. A normal contract through an estate agent, through print advertising, and the way they normally do it on Property 24 does not constitute direct marketing. Therefore, you would look at the footstewards clause, which is always standard in the offer. And that would come, the technicalities around this footstewards clause would often be looking at when is the seller liable for a defect, which comes down to latent and patent defects.
Now let's talk about that, because the footstewards clause says you buy as is, but there's a lot of confusion around defects to the property.
Yes.
Give us some insight there.
Well, for example, you could have a damp behind a cupboard, and if the seller reasonably knew that there was damp behind that cupboard and they placed the cupboard in front of it, they could still be liable because they knew about it and should have mentioned it. With a reasonable inspection, people expect the purchaser to go through the house and, flush the toilet and look at everything obvious. But a purchaser is not going to draw back cupboards and all of that, so they would not have known. If the seller was not aware at all of the damp issue, he is not liable, but it gets very tricky in that regard on proving that he didn't know.
That's my question. How do I, as a buyer, prove that the seller didn't know?
It's actually become prescribed by the Estate Agencies Affairs Board suggests is that a full disclosure agreement is signed prior. It's actually the best way to deal with the problem.
What are conditions of sale? Who makes these conditions, and do you have examples of these conditions?
Conditions of sale and suspensive conditions of sale specifically deals with the fact that something has to happen before this transaction is valid. For example, the most important is if it's subject to a bond approval, which gives the purchaser 14 days or 21 days to obtain his bond approval. If for some reason he does not qualify, the deal of sale will not continue. You also get other conditions of sale, for example, sale of a property, so will also be a time period to that. If the property doesn't sell, the purchaser is not obligated to continue with this sale. It's all about that date that needs to be specified.
Just clarify suspensive condition.
Yes. The word suspensive means that this offer is suspended until such time as a specific event happens, i.e. the sale of the property, bond approval being granted in principle, then it becomes a valid transaction.
Let's talk about fixtures and fittings.
Yes, everything that's that's affixed to the property will be seen as part of the property. But sometimes you have, something of a sentimental value, like a grandmother's stove that was built into the property. And if you had to remove that, firstly, there will be a big hole. It will be a problem. So you, again, deal with it prior, because it's deemed as being a fixture. Deal with it in the contract, specify that this is going to be removed and possibly replaced.
Charlene, talk to me about the occupation date and occupational rent. Why is it so important to specify these things in an offer to purchase?
You have a few scenarios of when transfer could be scheduled, and you will always have the clause referring to a specific transfer date, or as soon as possible thereafter, or simply as soon as possible. Then the next clause would be the occupation date. And the occupation date can also be specified, and this is where it gets tricky. It can be specified as also the 1st of July as the date, so whether transfer happens or not, or it could say on transfer. To protect a seller, we always advise that first prize is that the clause simply refers to occupation happening on transfer. Because if you have some delay at the deeds office, etc., and it was not your intention to have people move in earlier, problems can arise because they are in that property, and they now suddenly do notice mistakes and things that's not covered by the food stewards, and whether it is relevant and whether the seller is liable or not, they can make life very difficult because they are inside the property. You cannot simply get them out of the property.
Charlene, you are a conveyancing attorney. What does that mean? And tell me about your firm's offering.
A conveyancing attorney, Cornelius, means that we absolutely specialize in the transfer of property and all laws relating to that. At our firm, we focus on protecting the interests of the buyers and the sellers in their home buying journey. We always believe that by providing them with the correct information before the time, they can avoid a lot of unnecessary consequences and know exactly what they're in for.
Lovely chatting to you. Thanks so much.
Pleasure.